Back with the WMAY morning news feed. Let's talk about some of the latest rulings out of the Illinois Supreme Court when it comes to firearm legislation or laws, even those that are enacted locally by municipalities. One in particular deals with Deerfield, a suburb of the Chicago area, and a ban that they had on certain types of guns that they classified as assault weapons. And Deerfield implementing that back in 2018. Well, the Illinois Supreme Court yesterday issued a ruling, or did they? It was kind of a one-page order saying that they couldn't come to a decision because one justice recused themselves, leaving the others remaining split, so they couldn't come to a decision ultimately. To react to this is Guns Save Life's John Boch. He joins us here on the WMAY morning news feed. John, thanks for taking time with us this morning, and I want to thank you publicly for answering the text message at 4:30 this morning. So greatly appreciate that. How you doing today?
Well, good morning. It's good to be here, and thanks for having me. It's a beautiful day.
So I want to just read to you a statement from somebody who supports the Deerfield decision, and that is State Representative Bob Morgan. He put out a statement yesterday after the Illinois Supreme Court really, I guess, didn't make a decision on this other than to dismiss the case, not really ruling on the substance of some of the questions that were raised here. So here's his statement, and I'll read it to you and get your reaction. He said that it's a tremendous day for Deerfield. The Illinois Supreme Court decision affirms that local municipalities have the ability to control the weapons in their communities. This makes Deerfield safer and is a win for the community. So what's your response to Representative Morgan?
Well, it's an interesting interpretation of the decision. Bob Morgan should know that the Village of Deerfield was going for a full win from a split appellate court decision in our lawsuit challenging their gun and magazine ban. In the end, the Illinois Supreme Court accepted the appellate court's decision that the home rule municipality could make modifications to their ordinances. And we saw that as a disappointing decision, but it was what it was. But Bob Morgan lost on the magazine ban. He wanted to get the magazine ban reinstated, and that did not happen. And we all know that guns protect families, guns protect children, and that gun control is racist, classist, and sexist. And here is Bob Morgan advocating for racist, classist, and sexist gun control.
So, John, what happens now here with this issue of Deerfield? Are they emboldened to have this stay in place? And what does that portend for the rest of the state when it comes to state legislators who may want to mirror what Deerfield is doing?
Well, there was a 10-day window to amend local ordinances when the Illinois Concealed Carry Act passed back in 2013. And obviously that window has passed. So it's kind of a nothing burger as far as other municipalities go amending their ordinances. I think that will be a stretch for anybody else to try to do this. Deerfield had already made an amendment, and they were amending an amended ordinance. It's a long and complicated thing. The appellate court decision was 20-some pages long, single-space type. It's not an easy read. But the bottom line is that, Deerfield gets to have their scary gun ban, the police patrol rifle ban, the ban of America's favorite rifle. But it's only a ticketable offense, and they're not going to go door to door asking people if they have these guns. It's really just symbolism over substance is what it is.
What does that mean, though, for state legislators who might want to have a similar type of statewide prohibition on people being able to own certain types of rifles that have, accoutrements on them?
Well, state legislators have not been known to be terribly concerned about what the courts rule in the past, and I'm sure that's not going to change dramatically. I know the Illinois Supreme Court ruled just a couple of years ago, 7-0, that the Heller and McDonald decisions protecting the individual's right to keep and bear arms preclude the state from banning whole categories of weapons. So in that case was stun guns, but certainly a statewide blanket ban on America's favorite rifle, the AR-15, and similar guns would probably run into that buzzsaw, but we'll see when we get to it. I don't think the stomach or the legislature has the stomach right now to tackle banning America's favorite rifle and further benefiting the rich and wealthy in the state at the expense of the poor families that benefit most from keeping and bearing arms in the home and outside of the home to protect themselves and their families from violent crime that permeates Chicago and our other big cities here in Illinois, thanks to gang violence.
We're talking with John Boch from Guns Save Life here on the WMAY morning news feed. A couple of other things I wanted to touch base with you on. We had talked previously about the Illinois Supreme Court shooting down, pun intended, the ammo tax on, or the tax on ammo and guns in Cook County. Cook County quickly came back and changed their ordinance, saying that they have assuaged what they thought were the court's concerns here. What are you guys doing about this?
We've already filed a motion with the Illinois Supreme Court to block that, and furthermore, there has been a class action lawsuit filed to force Cook County to reimburse the millions of dollars they collected under the unconstitutional tax for the first number of years that it was in force. And I can't wait to see Cook County start writing checks to reimburse those individuals who had to pay the tax that was unconstitutional. So I think by the time all that's said and done, Cook County is going to be really sick and tired of hearing the name Gun Save Life, and I'm okay with that.
John, one other case that was out of the Illinois Supreme Court yesterday. It's a lengthy case, deals with just one individual. Tell us about the case Brown versus ISP.
That case was about a gentleman who had a misdemeanor domestic violence conviction from 20-some years ago in California. He claims that he picked up his wife in a bar and fell down. She was injured when he fell down. Ultimately, she was upset, called the police, and he took a plea bargain for misdemeanor domestic violence. The Supreme Court ruled that this guy's not a danger to himself or others, and the public would not be ill-served by him being issued a FOID card. And the Illinois Supreme Court ruled that the state police should issue him a FOID card and reinstate his firearm rights, which in his case is obviously a huge victory, but I see it as a step in the right direction for dealing with otherwise law-abiding people who had an incident in their past of a minor domestic violence incident. Being able to own guns once again here in Illinois.
Yeah, it's pretty incredible to watch all this play out in the state of Illinois, and we'll of course touch base on other issues moving forward here with John Boch. He is with Guns Save Life. Greatly appreciate you taking the time this morning, and we'll definitely connect again soon. All right.
Thanks, Rick. Take care.
You too. It is the WMAY morning news feed at 7:51 now. Your forecast, we're looking at a high of 45 degrees with the low down to 35. Saturday, mostly cloudy with a high of 54. And then Sunday, we're looking at cloudy skies with a high of 52. It's going to be frigid come Monday with a high of 36. Right now, about 25 degrees. Stay informed, stay connected. It's 7:51 on WMAY.
Give the gift of Culver's this season. Gift cards available now at Culver's West on Wabash.
The only thing consistent in life